Explain the requirements regarding records and the maintenance thereof in terms of other applicable legislation, including FICA. Part 2 of the FIC Act begins with the requirements in terms of record keeping for so-called accountable institutions, which at a time of conducting business may accept and hold funds or deposits on behalf of the public. The Act makes specific mention of the list of accountable institutions, which include, amongst others, attorneys, trust companies and trustees, estate agents, financial instrument traders, management companies in respect of unit trusts, banks, insurance brokers and agents, both long-term and short-term insurance, accountants. The above list was compiled from the point of view of popular money laundering avenues. For example, taking the proceeds of crime and investing in securities, property, bank products, endowment policies, unit trusts, and so on. The responsibility is therefore placed on the associated institutions to identify and verify clients investing in such a manner. Part 2 continues by listing the record-keeping requirements for accountable institutions whenever a business relationship is established or a transaction concluded with a client. This implies that these requirements don't only apply when conducting a transaction, but also when there is an intention to establish an ongoing business relationship. Remember also that the words client or person don't only apply to natural persons, but also juristic persons, such as companies. The accountable institution must keep record of the identity of the client, the identity of the person acting on behalf of the client, as well as the authority to do so. For example, a trustee acts on behalf of a trust or a director acts on behalf of a company. The identity and authority of the client acting on behalf of another person, the nature of the business relationship or transaction, where transaction is concluded, the amount as well as parties involved, the manner in which the identity was established, the name of the person who obtained any information, and copies of any document obtained for verification purposes which relates to the identity document and proof of residential address. The above records may be kept in electronic format. Where the records relate to establishing a business relationship, they should be maintained for 5 years from termination of such relationship, and where a transaction is concluded, at least 5 years from this date. A third party may also retain these records on behalf of the accountable institution, provided that free and easy access to these records is available. Responsibility for the records remains with the accountable institution. Details of the third party should be provided to the Financial Intelligence Center. Let's close off this outcome with an example. Jack is a member of Green CC and the financial manager. Green CC is a printing company which uses high-tech printers with a lifespan of approximately 5 years, which cost 10 million rand. Green CC will start an investment plan to pre-fund purchasing the next set of printing machines in 5 years' time. Jack approaches Yellow Fund managers to conclude the transaction. Can you identify the FIC Act record-keeping requirements for this transaction based on our discussion to date? Firstly, Jack is acting on behalf of Green CC and as such will need to identify himself and provide verification via his green barcoded ID document, driver's license or passport. He will also need to provide written authority, such as a mandate, to confirm that he is acting on behalf of Green CC. Jack will also prove the identity of Green CC and verify this with company registration documents as well as a proof of Green CC's business address. Finally, Green CC would need to verify the source of funds. Jack would likely provide a copy of the company bank statement and perhaps a cancelled check. Note in this case that Yellow Fund managers are the accountable institution.